Hi, I'm Amy Schmidt, and if you're just tuning in, I'm having an honest conversation with Christopher Hamilton from Willamette Elder Law. And we just finished talking about the differences between power of attorney, advance directives, guardians, and conservators. But a couple things that kind of came up in that topic were living wills, paperwork, kind of, documents. So there's a lot of terms that I hear a lot, and it's having a will and how important a will is, and that you need to avoid probate, which sounds like this deep, dark, scary thing. And then there's also a trust, and then there's also the living will. So I kind of wanted to break down with you, what is the difference between a living will, and a trust? So where do you want to bite that one off and start from?
So I'm going to kind of start from a setting the perspective point. When we're talking about most of those things, we're talking about what happens to your stuff when you're dead. And so the easiest way to
This is why I call it an honest conversation. It's like the bluntness, I think, makes it real.
Yeah. And so the place to start with that is, well, if I don't do anything, what happens?
Okay.
And so if you don't do anything, then in every state, the state government has made a plan for you. And so your stuff will pass according to what's called the rules of intestate succession, meaning without a will. And it will go through the state probate process, which is the court process of moving property from dead people to living people. Now there's some caveat to that, and the biggest piece is that probate process only attaches to things that are owned by a dead person in their name only.
So now, first, real quick, can you explain what probate is?
We'll get there.
Okay. Patience.
The first thing I want to say, attaching to what I was going through just there, is do not, for the love of God, add random people to your assets to avoid probate. I don't care who they are related to you. If they are not actually an owner, do not put their name on the title, the account, the whatever. You will cause yourself problems. And so for anything, though, that does have a joint owner, like a spouse or an account that really is multiple people's money, or a house that more than one person really did go in on together, those assets can be set up with survivorship so that whoever lives longer holds on to them, and we only have to worry about something when the last one of them passes. But those things, we also end up with things that have beneficiaries named on them.
Okay.
So like retirement accounts, life insurance policies, those kinds of things. Again, go to whoever the named beneficiary is.
So if something is joint property, or there's already a beneficiary named, those don't have to be part of a will, because they're already kind of handled.
Right. Those take care of themselves. There is no will, trust, nothing, non-planning that will impact those. Those will go according to the beneficiary designation or the joint owner, no matter what else we do.
So for a will, we're looking at things like, as you said, belong to a dead person that now don't belong to anyone, and no one has been named.
Right.
Got it.
The most common place this shows up, for starters, is a house.
Okay.
Because there isn't really a good way to transfer a house without either probate or a trust, unless we're talking about a married couple or others that actually bought a house together and wanted survivorship in that.
Got it.
And so probate is that court process of transferring property from a dead person to a living person or persons. And the basic process involves petitioning to tell the court that someone has died, letting the court know whether or not there is a will, letting the court know who we think the creditors are, and who the people who may or may not be getting anything out of that estate are, looking at both the default heirs in the state's intestate succession rules, and if there's a will, whoever those named beneficiaries in the will are.
Okay.
The court will then generally say, yeah, sure, that all looks great. That person can have the authority to deal with this estate. And then at that point, we can send out notices to creditors and the state and everybody else that's going to be getting notice and start looking at liquidating assets and moving things around. And somewhere between 9 months and 3 years later, we've got an estate ready for distribution.
That's a long time.
It certainly can be, yeah.
Okay. So probate, to me, it's always kind of seemed like a dirty word. Everybody's like, I got to avoid probate. Why is probate? Is it because of that 9 months to 3 years? What makes probate this thing everyone tries so hard to avoid? And should we be trying that hard to avoid it?
The three things about probate that are worth considering avoiding are time, cost, and public record.
Okay.
Because dealing with things in probate takes longer than dealing with them in any other reasonable way. It costs more than dealing with them in any other reasonable way. And probate is a court process, which means everything that happens in probate is public record.
Okay.
And so, that said, those aren't terrible things depending on your circumstances.
Got it.
There are situations where, accepting that we're going to do a will, we're going to go through probate, it's going to be relatively simple, is a better answer than trying to set up a trust or trying to do any other convoluted planning to avoid probate.
Okay. So, what should be included in a will, and what is a will?
So, now that we know kind of what happens without a plan, the next big thing that people get wrong or get confused when they're getting information off the internet is thinking that a will gets us out of probate. It does not. All a will does is give us a roadmap through the probate process. It names who should be in charge, it says who should get stuff, and it can change the rules related to how things pass or how the person in charge of things, called a personal representative here in Oregon, also called an executor, and a number of other things depending on where you're at.
So you talk about like who gets stuff. So the state may deem the heirs naturally are a spouse and these 3 children because they're there. But the person may have decided, I want it to only go to this child because they have special needs. Or I have a husband or children from previous marriage. So by doing the will, you're saying, I don't care what the state would have said, this is where I want it to go.
Right. And, the will can have absolutely nothing to do with where, what the state calls the natural objects of your bounty, your spouse, your kids, your other descendants. It can say, screw all of them, and this is going to, my friend Sally, because they're the only person that actually showed up for the last 20 years.
Or the Humane Society, or a nonprofit. Okay. But if you don't have a will, the state's going to follow what their rules are on who they deem your heirs are.
Yep, and that'll be spouse if you have one. If you've got kids that are not with that spouse, the spouse and the kids not with that spouse will split everything down the middle. If there is no spouse...
Depending on the state.
In Oregon.
Because that's where we are, in case y'all did not know that. So we're trying to make this as general as possible, but at the same time, it is very different from state to state. And people move. So another reason to make sure those documents are updated.
Yes. Anytime you change state of residence, please see an attorney in that state to make sure your plan still works. Because usually they're close enough that a plan from one state will work in another. It may not be ideal, but it'll work. Every once in a while, you run into a spot where the rules are different enough that a plan that works here is wrong for being somewhere else.
Got it. Okay, so going through probate, whether you have a will or don't, you're going through probate.
Yep.
And so it's to, tell of your death, see if there is a will, let creditors know, and then go to either the default heirs or who the will has said it needs to go to.
Yes.
Got it. So a will is just pretty much like how you would like things to be distributed, your wishes.
You get to pick the who, and also, very important in a lot of situations, you get to pick the how. Because, like the example Amy brought up of having a child who is, going through life with a disability that is qualifying them for state benefits, getting a giant pile of money will screw up their life because they will stop qualifying for any means-tested benefit if they just get a lump of cash. Or
so that's part of the estate planning part of your job.
Yes.
We're going to have to talk about that in a different one of these, but we'll come back. I'm writing myself a note right now. All right. All right, so talk to me about a trust. So what is a trust, and do you have that with a will or in place of? And if so, when?
So a trust is an alternative to a will mostly. And the point of a trust is to avoid probate. So you get faster, cheaper, private distribution of the resources.
So do you have to be wealthy to have a trust? Because that's what I hear a lot. People are like, oh, I don't have enough things I don't have enough income or enough wealth to have a trust.
There are a few things that trigger a conversation about a trust being more than a matter of personal choice around probate. And how much is one of those things. But really, it's less about how much and more about how complicated the assets are. Because if I've got, $9 million all in cash, then, I should do some tax-related planning, but that'll still be a fairly simple thing to deal with when I'm gone. Whereas if I've got $9 million worth of assorted real estate, that we really should be running through a trust, because that gets much more complicated much more quickly.
Having younger children separately. Or maybe children that are 18 that you did not want to leave a large sum of money. Would that be a reason to have a trust instead of a will?
Yes, if you've got beneficiaries where either it needs to get to them quickly, like minor children who should, be able to eat before we could get money out of your estate. And having beneficiaries who shouldn't receive money directly are good reasons to have a trust.
Okay.
Now, we can make some provisions for those beneficiaries who shouldn't get their money directly in a will, but it will run much more smoothly and effectively through with starting out of a trust.
Okay. What are the other differences of a trust and a will?
So the other times where it makes a lot of sense to look at a trust are when we have those kinds of complicated assets or multiple, especially if we start having real estate in multiple states, because every state wants to control its own dirt, which means that we've got probate in every state where we own dirt.
Oh, Lord.
And a trust skips that. And we have one administrating procedure for all of it instead of, 6-7 probates if you're really spread across the country.
So if you have real estate in different areas, you got to go through probate in different states. If you have a trust, does it just happen where the body passed away, or where does the trust paperwork get handled and how?
So the trust gets administered wherever the trust says it gets administered.
Okay.
There has to be some reasonable connection
so it's written in the document.
To it, but usually it'll be the state the trust got drafted in.
Okay. So even if you move later on, it's probably going to get done in the state where it was created.
Or at least under those laws.
Okay.
You can update everything about a trust, so again, when you move, that can be fixed. But if it isn't, then you may end up looking to laws that no longer have anything to do with your life.
Awesome.
And then whoever that trustee named in the trust to step in when you're either incapacitated or dead they will take care of tax paperwork in each state that needs dealing with and all of those pieces, but we can avoid having multiple court processes going on.
So with a trust, it's confidential because it's not going through court proceedings. Sounds like it's faster. How long does a trust typically, I know like wills being a range of, 9 months to 3 years. What's a trust look like?
The average trust can get administered within the first year.
Okay.
If we've got assets that are relatively easy to sell or transition to new owners. If we've got business holdings or other things, sometimes the trust will end up open for a while, but it will be at that point usually distributing most of the income to whoever's supposed to be getting it. They may just be some delays in dealing with the business assets or leases or whatever.
Okay.
And that's another one of the reasons to look at a trust over a will, is if we've got a business involved or multiple businesses, because if the only decision maker in a business dies without a trust, we can't do anything in that business until somebody is appointed as a personal representative in probate, meaning we can't pay payroll. We can't pay suppliers. And that can cause a business to stop existing real quick.
And it may be a very large asset.
Yeah.
Got it.
And if that's most of your estate, having that go belly up on you right after you pass is really a problem. Whereas with a trust, you can name a trustee who can step in more or less immediately in your ownership role and keep things going.
Got it.
So that, the bills get paid and the business either continues operating or winds down in a controlled state.
Got it. All right, so we've talked about wills, living wills, probate, and trust. Is there anything that you feel was like missed in there that should have been said?
So we actually technically didn't talk about living wills.
Oh, we didn't.
Other than when we were talking about advance directives.
Okay, well, let's talk
And-
about that in the next one because I feel like that might be a little bit more of a thing. So thanks
Yeah.
for catching me on that. So we'll do another one on living wills. Thank you, Christopher.